Let me just take a moment and introduce myself. My name's Elizabeth Copper-Bush. I'm co-director of the Center for American Studies here at Christopher Newport University, and also director of the American Studies program. Our center supports undergraduate and faculty scholarship on America's founding principles in history, economic foundations, and national security in order to promote sensible notions of political and economic liberty and to encourage civic responsibility. What is Constitution Day? This is a day that commemorates the formation and signing of the U.S. Constitution on September 17th, 1787. Here at the Center for American Studies, we commemorate this day by holding a debate on an issue of important contemporary times. We do this for a very specific reason. It is our intention to try to restore Americans' faith in the civil conversation and disagreement, and that intelligent people can disagree on important issues. And I think our two guests today will be evidence of that. I've heard something about another debate going on later today.
This one's way more interesting.
And I can promise you that ours will be more substantive, probably equally entertaining. Let me just take one more moment to thank our sponsors, the TWS Foundation, the National Endowment for the Humanities, Templeton Foundation, the Jack Miller Center, and IHS, as well as the support system here at CNU, our colleges, and our provost's office. We very much appreciate all the support. And events like these may look seamless, but let me promise you they are not. We have a team of junior fellows and ambassadors and faculty who help, and I would like those students to please stand up and be recognized so I can thank them all. Yes, they're in the front row and they're giving a look like they don't want to. And I have one introduction to make. I'm going to introduce our moderator, who will be introducing formally our guests. Ronnie Cohen is a professor of business law in the Luter School of Business. Her areas of research are critical legal studies as applied to corporate law and law and emotion. She's written numerous articles on these subjects and has been cited by the Canadian Supreme Court. She received her BA from Kirkland College and her JD and LLM in taxation from William & Mary. Prior to joining the faculty here at Christopher Newport University, Professor Cohen practiced law, and she still does some pro bono work for local nonprofits. So would you please join me in welcoming our moderator, who will introduce our guests.
So thank you very much, and welcome everyone to the 2016 Constitution Day event at CNU. I don't know about you, but I brought my very first copy of the Constitution with me. I got this in the 6th grade, and I was just sharing it with our guests. It only goes up to the 22nd Amendment. That's just how old I am. So when this was the Constitution, you all would not be able to vote because the vote was still 21. But anyway, I keep it because it reminds me how important the Constitution is to our lives, and I like to talk about it. And I teach it in my classes. Even though I do teach business law, the Constitution is even important for business. And I hope that you also, by coming to this session, will begin to think about how important the Constitution is to you and to a democratic society. So I'm very honored to be invited to moderate this debate, and which, by the way, as Liz mentioned, and one of our guests has already commented, will be the best debate that you hear today. So shortly after 9/11, Congress passed a law called the Patriot Act, which you may recall. And privacy advocates at that time worried that the FBI or other government officials might access information on the records of books checked out by public library patrons. Well, we've come a long way since then, and more recently we've heard revelations about information gathering by the National Security Agency, and the most recent court case involving the cell phone information of the San Bernardino attackers. So while privacy advocates worry that personal data on our phones, on other devices, and in social media should not be subject to data mining by the government. Others believe that the government should expand its use of information in order to combat terrorism. And that brings us to the topic of this year's debate: cell phones, social media, and civil rights, the constitutional limits of data mining. It's a timely and important topic, and we're so fortunate to have guests who can help us understand the conflicting and complicated issues in the context of American constitutional principles. Seth Stoddard was, on my right, was appointed by President Obama to serve as the Assistant Secretary of Homeland Security for Threat Prevention and Security Policy. He leads a team advising Secretary Johnson and senior DHS leadership on a wide variety of issues relating to security threats to the United States homeland and on how to address them while preserving civil liberties and privacy rights. Stoddard teaches counterterrorism, civil liberties, and privacy law at the University of Southern California Law School. Earlier in his career, Stoddard served in the George W. Bush administration as Director of Policy and Planning for U.S. Customs and Border Protection and Counselor Senior Policy Advisor for CBP Commissioner Robert C. Bonner. On my left is David Cole, who teaches constitutional law, national security, and criminal justice at Georgetown University Law Center. He is also the legal affairs correspondent for The Nation and a regular contributor to the New York Review of Books. He's been published widely in law journals and the popular press, including the Yale Law Journal, California Law Review, Stanford Law Review, the New York Times, Washington Post, among many others. He received his bachelor's degree and law degree from Yale and has been involved in many of the nation's most important cases involving civil liberties and national securities, including the case of Maher Arar, a Canadian citizen rendered to Syria by U.S. officials and tortured there. So each presenter will speak for about 15 minutes, and then each will have 5 minutes to comment on the other's address. And after that, I will open it up to questions. I hope you'll have a lot of questions, and I encourage you, if you do, to jot them down as you're hearing the speakers so that you have them and that you're ready to ask them at the conclusion of our presentation. So with no further ado, Seth Stoddard will be going first.
Great. First off, thank you for having me. It's terrific to be here and talk about these issues that unfortunately 15 minutes could be 15 hours, 15, these are very complex, interesting issues that I hope you all can sink your teeth in to over this next 90 minutes or however long it's going to be. I guess, the way I would sort of start this is, I think these are not black and white issues. This is not a binary kind of debate. These are issues that are, and really fundamentally you're talking about how do you balance kind of competing imperatives, whether it be one incredibly important imperative is the security of our population and also the enforcement of our laws. Another incredibly important imperative is the protection of our privacy rights. Another is the protection of our economy and the free flowing of our economy. And another incredibly important one is our civil liberties, beyond privacy, due process, and all that. And the question is, for any given situation that we've faced in our country, how do you balance all of those together? And this is not the first time, this isn't our first rodeo as we think about this. We think about how we balance these issues in the context of the time after the founding of the Republic, or during the Civil War, or during World War I, or the Second World War, or the Cold War, or the Vietnam War. And this is, the time that we've been facing since 9/11 is another iteration of that debate and how we draw the right balance between these different competing imperatives. And then the other sort of constant that we see here is there are two big constants that you're seeing. One is the pace of technology, and the technology growth the technology is changing dramatically. So the telephones that the Supreme Court looked at in Olmstead back in the 1930s, as we think about the wiretapping back then, totally different from WhatsApp or Wicker and end-to-end encryption, encrypted communications. So that's one, the technology races forward significantly. And then the other constant that we are seeing is globalization and the explosion in the movements. What I like to think of, I'm in the Department of Homeland Security, so much of what we do, in addition to threat prevention, I serve actually as Assistant Secretary for Borders and Immigration and Trade as well, and policy. And you think about the DHS role, in some sense, it's about securing globalization and the key global flows that cross our borders, whether it be the movement of people, things, goods, money, and data, fundamentally. And so we have to draw all these balances of these competing imperatives in the context of an incredibly dynamic global economy, where you have literally millions and millions of people crossing international borders every single day. So the question here is, we think about, how do we think about these areas in the context of the three topics we're going to focus on today, which is the use of data mining to identify and spot threats, and also importantly, the use of data mining to identify low risk, say at the border context, low risk travelers that can be sped through the border, or say TSA. Anybody use PreCheck? Okay, it's a pretty good program. The only way you can PreCheck can work is if we have information about people and we can identify somebody who's a low risk person that can be allowed to go through an airport checkpoint without taking off their shoes, et cetera. So that's data mining. The use of social media. Social media, when you think about as we've thought about these cases, these types of balances before in earlier times in our history, obviously social media and the cloud didn't exist. Although, people always did post their opinions in public places. And so the question is, should our understanding of what is the public and private realm, what's the public street, what's the signpost that somebody puts a viewpoint on in the public street, should our conception of that also apply to public postings on social media? So when you think about, let's take a specific example that I'm sure will be debated in the other debate tonight, which is the Syrian refugees. So we think about, I think many of us, and myself included, feel that the United States should be very aggressive in meeting our humanitarian obligations to the Syrian refugees and bringing them to safety as much as we can. Well, but except the American public isn't going to tolerate essentially the movement of sort of large numbers of people from a dangerous part of the world without vetting them, screening people. Well, how do you vet and screen people who are coming out of Syria, maybe in a refugee camp in Turkey or Jordan for a while, before coming here? And how do you go through the steps of determining whether or not this person could present a threat to the American public? Well, you have to vet them. And the intelligence community knows something about certain people, but not a lot. Never overestimate the amount of information that the intelligence community knows about people. But one thing, wouldn't you want to know whether a particular person that you'd want to bring in to have humanitarian protection, whether that person may have made postings on social media sites that might indicate that they might be affiliated with ISIS? Wouldn't you want to know that before we let that person be resettled into the United States and live in this community right here? You might want to know that. And that's an example of the use of social media, that you might want to know whether somebody's posted something on Instagram saying, I am a terrorist. Obvious, ridiculous example, but you might want to know that before you say, yep, we're going to let this person into our country and resettle here in Newport News. And then I think the third topic that we've talked about is this issue of encryption. And that is, in some sense, I think the most difficult topic of all, because I think I talked about the various balances in terms of how we in the administration look at this issue. And on the one hand, I think the issue of encrypted communications, especially end-to-end encryption in transit, not just the San Bernardino case, which is actually in some ways an easy case, where you have, whatever's on this device is encrypted, and, well, we got to figure out whether we should have the ability to essentially go into a locked container, which is locked by data, some sort of software, rather than a key. The harder case, in some sense, is encryption in transit, of data in transit, of end-to-end encryption, and whether the government, like we do in other contexts, there's a warrant issued by a judge allowing for an intercept warrant for intercepting communications. In other contexts, of course we've allowed that, and that's going way back in our history. It's cabined by the Fourth Amendment and other statutory provisions. But for the most part, of course, we've allowed law enforcement or security officers to get a warrant for the interception of communications. Why should the movement of text messages on WhatsApp be any different? And the answer to that is that it's actually a difficult question, because of the growth of encryption. Not only because of the concern, well, if government were to have a key to break into encryption of WhatsApp or Wicker or something like that, well, who's to say that the Chinese shouldn't have that kind of key as well to break into those communications? And then there's also, I mentioned the various competing policy issues as well, and one of them is our economy. Well, if you start allowing government to have the keys to break encryption, are you essentially threatening cybersecurity of all of us? And if you think, the way our economy runs, it's interesting. I was reading a discussion of sort of the rise of money in society over the last thousands of years or so. And I think the Latin root of the term credo, is belief. So in some sense, money is about belief. If you believe that money has value, or something like this pen has value as a currency, well, then you're willing to give up something else for this pen. But if you don't have adequate cybersecurity, and you put your money in a bank, and the bank loses all of its money to hackers from outside, your faith in that system goes away. And so that's the other part of the balance here as we think about the encryption issue, is how do you balance also the need for the economy and the need for essentially the security of the internet in how we think about what government policy should be, and whether we should be requiring companies to allow for keys or some sort of backdoor to allow for the enforcement of a judicial warrant under due process of law to allow for the interception of encrypted communications. So anyway, I raise these, I sort of give this sort of introduction as to sort of think about how to frame this issue as we debate it. These are very difficult issues, and they're not black and white. And the other thing, I guess the things I would close on is to sort of say, we were in a Q&A session before that I joined very, very extraordinarily late to. One of the things that came up was the concept of a pendulum and sort of how we sort of think about these issues. And I think that's a good way of looking at it in the sense of there's no one right answer to any of these types of questions that will apply for all times. And it all depends on, in some sense, the outside world and the pressures that are on this in terms of what the public and the policymakers need to do to solve a problem. So whether that problem might be secure the public, or that problem might be bring Syrian refugees to the United States, or that problem might be how do we sift through the millions of people who every day are coming across, the San Ysidro port of entry into the United States from Tijuana, in determining who might be a threat or somebody who could present a threat to the American public. How do you sift through all these people, these millions of people? Whatever policy, and essentially all of these issues are subjected to the lens of the times. And so never believe anybody who says that there's an immutable principle one way or the other on any of these issues, that these are all subject to debate. And I think on that, what I'll close with is I think an interesting, for those of you who are interested in going on to law school, one of the most interesting sets of opinions, I think, that really sort of capture the issues in these areas is a case called United States versus Jones from a few years ago, a Supreme Court case, where the court really fragmented. It was a case involving GPS trackers in D.C. In terms of the ability to sort of put a GPS tracker on a car. And the majority of the court basically got off easy and basically said, well, you put it on a car, so it's a trespass to chattels, and so, Fourth Amendment violation. But the really interesting issue is essentially the issues that we're going to talk about today, which is how do you balance security, liberty, and privacy in the context of a world where the technology of today is radically beyond the technology that existed when a lot of the Supreme Court precedents that govern this area were handed down, so back in the 1970s and the 1960s. And so, it's an interesting set of opinions that sort of tries to wrestle with these issues. And I think it'll give you a good illustration, I think, on both sides of this debate, how hard these issues are to sort through. And in the context of, in my job, I get intelligence briefings every single day that emphasize to me that the threats that we all face are real and ever present. So when anybody says to you, well, these issues are easy, we should just, live up to our humanitarian obligations and let 1 million Syrian refugees in, or not use data mining, or not think about whether we should be tapping into, with a judicial warrant, the communications of ISIS plotters. that might be moving on encrypted networks. Think carefully about that, because the threats that we all face, while we shouldn't overstate them, I mean, this isn't the Cuban Missile Crisis, but the threats that we all face are real, and I think the public in the United States, as well as in Europe and other places around, I mean, they do expect us to be empowered to address them, and I think, so in that context, I think I'll stop there and sort of leave it at that. It's sort of a framing of the issue, and I'll turn it back over.
Thank you.
Thank you.
Professor.
Thanks. Thanks for having me. I was here, I think, a couple of years ago, and I note that while I'm back, the person I was debating against chose not to come back. So,
well, we'll see whether I'm intimidated this time.
I will say that I'm at least as prepared for this debate as Donald Trump is for his later debate tonight. And the real question I have for Seth is, in his many debate preparation sessions for this debate, who played me? Was it George Clooney or Matt Damon?
Matt Damon.
Okay, good.
You look more like Jason. You look more like Jason Bourne. So yeah.
My view is that there is an immutable principle that should guide us, and that is that the government should not be intruding upon our privacy unless it has a very good reason for doing so, and the good reason that has guided us for 2+ centuries is where they develop probable cause to believe that we're engaged in some sort of wrongdoing, and they can demonstrate to a neutral judge that they have that evidence, then they should be able to intrude upon our privacy, but not before then. And what concerns me about the brave new world in which we live and in which the government operates is that it can intrude upon our privacy in unheard of ways without that kind of individualized suspicion, without going to a judge, without demonstrating that it has some reason to believe that we are engaged in wrongdoing. In the old days, which means sort of, basically slightly before you were born, if the government wanted to know your deepest secrets, it had some options. It could assign someone to follow you around 24/7. So that's pretty hard to do, it's pretty expensive, but they could do that. It could also search your home, but it could only search your home if it first demonstrated that it had probable cause that you had engaged in some sort of criminal wrongdoing. It could interrogate you about what you were thinking, what you were reading, but you would have a Fifth Amendment right not to be compelled to answer those questions if they might lead to any sort of incriminating information. So the government could indeed find out information about us, but there were serious obstacles to doing so. It costs a lot, and it's really difficult to follow someone 24/7. You have to have that probable cause to go into a house, and you can't interrogate someone who asserts the Fifth Amendment. Today, all the government needs to do is contact your phone company, your internet service provider, your bank, your credit card company, and it can get from them information that will disclose far more about your most intimate details of your personal life than it could have gotten before by following you 24/7, searching your home, and interrogating you. Because virtually everything we do these days leaves a digital trace. When we send an email, when we search the internet, when we purchase something with a credit card, when we send a text or make a phone call, and even when we simply carry our smartphones with us. Most of you probably have your phones here today, and as a result, the phone company knows you're here. They know you're here because your phone company is constantly pinging some cell tower somewhere, and they have a record of where you are. The government can get all of that information under current constitutional doctrine. The government can get your cell phone location data. It can get who you're texting and receiving texts from, who you're calling and receiving calls from, what your credit card purchases are, what your bank record information is, what your web browsing activity is. All of that information is available to the government under constitutional doctrine today, at least as the government argues it, including the Obama administration, because you have given that information over to some third party, the phone company, the credit card company, the bank, the internet service provider, and therefore the government argues, based on decisions from the analog era, that is before all of this digital revolution occurred, you have no expectation of privacy in that information that is protected by the Constitution. None whatsoever. And because you have no constitutional protection, no Fourth Amendment protection, they need not get a warrant from a judge. They need not make a showing of probable cause. They need not have any justification for collecting that information. And that's what frees the government up to engage in data mining. Because what data mining is collecting a lot of information about innocent people, about innocent people's activities, and then searching through it for suspicious signs, suspicious activity, and the like. But should the government be able to know where we've been 24/7 for the last 3 months? Should the government be able to know every website that you have searched or browsed over the last 6 months? Should it be able to know every person you have communicated with by text, by phone, by email, without any showing of a need, without any showing of individualized suspicion? I don't think so. Now you might say, well, this is scary hypothetically, but it's really just hypothetical. Well, it's not. Unfortunately, it's not a hypothetical. Edward Snowden showed us that it's not a hypothetical when he, through his disclosures, demonstrated that the NSA had been collecting metadata on our phone calls, every one of our phone calls, for 7 years. Not on phone calls of suspected terrorists, not on phone calls of ISIS members, but on phone calls between me and my daughter, between you and your girlfriend, between you and your grandmother. All of them. How was it able to do that as a constitutional matter? Because the government says you have no expectation of privacy in that information because you shared it with the phone company in order to make the phone call. You shared it with the internet service provider in order to use the internet. So my position is not that the government should not engage in surveillance, and not that it shouldn't do what it needs to do to keep us secure, but that if privacy is to retain anything like the value that it has had for us as a nation for 2+ centuries, it is critical that constitutional doctrine reflect the changes in technology to preserve that privacy which is critical to our personal development as human beings, to our dignity. One of the easiest ways you can deny a human being his dignity is subject him or her to constant surveillance so that they have no privacy, no intimacy, no time to themselves. It's also critical to our continuation as a democracy, because in order for people to be free to engage in different kinds of thinking, in different kinds of associations and the like, you need to have the protection of privacy. So it's critical that we maintain that privacy, and yet technology has eroded that privacy by making it possible for the government to get information about us, any of us or all of us, that it previously could not possibly have gotten. If 10 years ago, 15 years ago, the government wanted to know what I had read 3 months ago, on this day, 3 months ago today, they could not have found out. There would be no way for them to find out. They could ask me, but I wouldn't remember. They could search my home, but that wouldn't show what I was reading 3 months ago. But now they can simply go to the internet service provider and look at what I searched on the web 3 months ago. That's what I was reading 3 months ago, and it's all there, a record. And it can be searched by computer in very cheap ways. So the government has extraordinarily expanded opportunities and abilities to watch us and to watch all of us at very low cost. It just couldn't do that before. And if law doesn't respond by creating legal rules that constrain the government from interfering with our private lives until it has good reason to do so, probable cause, then we have given up our privacy. Now, I'll close with just three signs of hope, I guess, in this regard. One is that in the wake of the in the wake of Edward Snowden's disclosures, in which we learned that these were not hypothetical concerns, these were real concerns. This is what the NSA was actually doing to all of us on a daily basis. We responded. We, the people, responded. We put pressure on our Congress people. We put pressure on the administration, and they responded. President Obama unilaterally reined in the NSA when this was disclosed. As long as it was secret, he was willing to go along with it. But when it was disclosed and people started complaining, he reined it in. Congress, which had reauthorized the predicate law that the NSA was abusing for this purpose 7 times, as long as the program was secret, when it became public, they rescinded the authority in something called the USA Freedom Act. So both the President and Congress, responding to the people's concerns, said, wait a minute, no, we need limits on the government's ability, even when it's trying to stop terrorist attacks, we need limits to protect our privacy. So that's a reason for hope on the executive side, a reason for hope on the congressional side. There's also a reason for hope on the judicial side. 2 cases I'm going to mention, one Seth mentioned, and then another he didn't mention. These are the only 2 cases the Supreme Court has yet confronted in which the question was, how should the Fourth Amendment apply in the digital age? And in both cases, the government took the position, the Obama administration took the position, that the Fourth Amendment should apply in the digital age just like it applied in the analog age, no extra protections whatsoever, notwithstanding the fact that the government had much greater abilities and authorities because of the digital abilities it has. So the Jones case that Seth mentioned, the government is following a drug dealer. They instead of following him 24/7, they stick a GPS on the bottom of his car, and they use that GPS to record 24/7 where he goes for a month. Where he goes for a month, and he goes very often to one particular house, and it turns out that's a crack house. The case goes up to the Supreme Court, and the government says, well, in the analog era, the Supreme Court held that it was okay for us to follow somebody from point A to point B in public using a beeper, because when someone's going from point A to point B in public, they don't have any expectation of privacy. And therefore, we don't need any probable cause. We don't need a warrant. There is no expectation of privacy. And they said, well, if that's true about going from point A to point B, all we did with respect to Mr. Jones was follow him from point A to point B to point C to point D to point E, point F to point G, 24/7 for a month, and zero, if each one is a public, is in public, and there's no expectation of privacy, and therefore there's zero expectation of privacy in going from A to B, and zero from B to C, well, simple math would tell you 0 plus 0 plus 0 plus 0 plus 0 equals 0. There's no expectation of privacy. You ought to apply the analog era precedent to this digital era technology. And Seth's right. 5 justices said, well, we don't need to address that question because when you put the thing on the car, you committed a trespass, and that's a Fourth Amendment violation. But 5 justices also said, no, we don't think that's the reason it's a violation, but we think it's a violation because we have a reasonable expectation that the government will not follow us 24/7. Will not follow us 24/7 for a month, even in public. And therefore, they have to get a warrant and probable cause. Second case, and then I'll stop. Reilly versus California, a case in which the question was, what can the government do when it arrests you and you have a cell phone on you? Can it search the cell phone? And there's a long line of cases from the analog era saying that the government, when it arrests you, can search anything on your person and any container you have. So your backpack, your purse, whatever you have on you, they can search automatically. And the government said, we should have that should be the rule with respect to cell phones. They're no different from any other container. Should apply the analog era to the digital era. They lost that case 9-0, as they lost the Jones case 9-0. And what the Supreme Court said in the Reilly case was, a cell phone is not like any other container. It has more private information in it than your home does. And we're not going to let the government, simply by virtue of any routine arrest, search through your home, through your cell phone. And therefore, instead, what the government has to do is get a warrant, make a showing of probable cause, make a showing of need based upon a reason to believe it's going to find evidence of crime. So that's the immutable principle that I think we ought to be relying upon. But in order to ensure that that principle, that the government not invade your privacy unless it has a reason to believe that it can demonstrate objectively to a judge in advance, is to be preserved, we need to update constitutional doctrine, not blindly adhere to the analog era as the government has argued, but rather, as the Supreme Court has said unanimously in the 2 cases it's had thus far, update the Fourth Amendment to reflect the much greater power that the government has to invade our privacy today.
Thank you. So now I'm going to give each of our speakers an opportunity to respond to the comments of the other. And so, Seth?
Great. Thank you. I think what I'll do is I want to zero in, I think, help us kind of zero in on the issue, because I don't think there is any one immutable principle. I think there are many, and these principles sort of shift. But let me just zero down on first off. For one, I'm from the Department of Homeland Security, as I say, and a key mission, as we say, is the protection of our borders. And as I talk about the issues of the Syrian refugees, or let's say the use of analysis of social media for people from Germany, for instance, who are trying to get a travel to the United States under the visa waiver program or something like that. Most of the effort from DHS in focusing in on, for instance, the use of social media to vet and screen people is in the context of border protection. And there's a long history of one immutable principle, I think, for border protection has been that this is where government's power is at its zenith, and that historically the government has not needed probable cause or even reasonable suspicion or a warrant or anything like that to search through anybody's baggage, goods, whatever else, for entry into the United States. A. And B, the government has always had plenary power in the immigration context to ask questions of anybody who's seeking to enter the United States to establish their right to come, their admissibility into the United States. So in that context, I mean, a lot of the effort here has been focused on border security. Now, there's an interesting issue. I mean, Professor Cole identified the issue of whether a cell phone is a container. That issue is being litigated significantly in the border context, in the sense of there are a number of cases that have gone one way or the other with regard to when, say, Customs and Border Protection seizes a cell phone at the border, and the position of the government has been, our position has been, this is a container in the same way that a briefcase is a container or anything else coming across an international border. And so the government has the ability to seize that and search it however long it takes to accomplish that. Now, encryption makes that difficult, and as the litigation has arisen from that has been, well, how long can you hold on to this cell phone while you're doing that search? And if the answer is, well, as long as it takes to break encryption, that could be a very long time. So that's one issue that's sort of, a specific issue. The issue of encryption, I think has to be subdivided into two. One is, as I mentioned, the issue of encryption of whether the government has the ability to intercept communications in transit. I mean, I think there the analog principles, I think, they apply in the sense that the government needs probable cause, generally speaking. There's some exceptions, but generally needs probable cause to intercept contemporaneous communications, whether they take place on a phone, by text, by email, whatever, under the Fourth Amendment or under the Electronic Communications Privacy Act or other laws of Congress. And so for data in transit. The issue, I think, that is the particular issue, though, there are two issues I think that Professor Cole sort of identified that I think are very much, focuses of debate here. One is I think there is, we have to sort of have this discussion of what do we mean by a private space. Because it is true that, I mean, it's general principle of Fourth Amendment law that where you have a reasonable expectation of privacy, government is not allowed to intrude on that space of that zone of privacy absent probable cause, often requiring a warrant. But the question is, what is that private space, and where do people have a reasonable expectation of privacy? Do you have a reasonable expectation of privacy walking down the street? Do you have a reasonable expectation of privacy posting a sign on a public walkway? And should that principle apply to do you have a reasonable expectation of privacy in putting a post on Facebook that's not protected by a privacy wall, that is just open to the public-facing message on Facebook? Do you have a reasonable expectation of privacy in the content of that message on Facebook or a picture on Instagram? That is a public-facing website. And I think the areas where David identifies, which is the issue of data mining and the amount of data that we all we have to to live in our society, we have to deal with third parties and we give information to them in order to function. That was true, actually, to an extent, as certainly in the 70s as well, when these precedents came down, including one involving bank records. And Congress responded to the bank records case with the Bank Secrecy Act and also the Pen Register Act and a number of pieces of legislation that responded to those Fourth Amendment cases from the 70s that said that we had no reasonable expectation of privacy in information that we give voluntarily to a third party. And so the question is, I think that the Snowden case and the metadata case identifies and focuses in on is in the domestic context, and I'm going to separate that from the border context. Where the government has far more ability to look at information and things coming across borders. But in the domestic context, what is the right balance to draw here? And should Congress respond by amending a number of the statutes that have really been on the books for decades, like the Electronic Communications Privacy Act and the Stored Communications Act, which govern essentially what government can do to look at electronic communications. That was enacted in the 1980s, so before the cloud even existed, other than water vapor in the sky. These are areas that certainly require focus and thought. Now, having said that, again, I go back to sort of the point I made before, which is that the threat that we are facing is real, and the issue here, I think, say with regard to the metadata discussion from the NSA, and here I'm speaking, I'm a DHS person, so I'm not speaking on behalf of the NSA here, or the FBI, in terms of what the focus is on metadata. But remember what metadata is. I mean, it's not, again, the immutable principle, at least for a long time, has been that the content of communications, before the government has the ability to look at the content of communications, so intercept communications, you'd need probable cause and a warrant. But the reality is, the information that you were talking about here, including especially the metadata, is not the content of communications. It is more like the information that was at issue in the 1970s cases. So records of this phone number called this phone number for X amount of time. So then the need for this information is, for instance, and what this is about is essentially, let's say the government knows the phone number for Ayman al-Zawahiri in Pakistan. And we know, and we're tracking that person, that phone number. And that phone number calls this phone number, which calls this phone number, which calls this phone number. Wouldn't you want their government, essentially, even without looking at the records or the actual content of those communications, wouldn't you want the government to be able to draw the linkages back to a known terrorist and actually be able to draw a whatever that network is, so you can actually have the government go talk to these people who are communicating 1, 2, or 3 steps removed from a known terrorist overseas? And that's what essentially the question is. And sort of, and if you're in a world where you're not talking about the content of the communication, so the issue of probable cause is off the table. We've never required probable cause for, or a warrant, a warrant founded upon probable cause, for the government to identify essentially literally just the phone numbers or just the data going back and forth. We've only required that for the content of the communications themselves. And the Congress in the Pen Register Act basically only required essentially relevance to a criminal investigation for the government to be able to actually obtain this metadata type information. And given that we want to be able to, we will not know essentially the level of detail of a network until we see the network. And you need the amount of information that is out there in terms of who these people are calling to draw that network. I think to require probable cause in that context would, I think, leave us fundamentally unsafe, because it would thwart the ability of our intelligence agencies and the FBI to identify the networks that would tie people to known terrorists who are conceivably plotting harm to our population. And I think, of course, we have to have. The question then is, well, what's the restraint? And I think David's right in the sense of the Snowden revelations certainly pushed both the executive branch and the Congress to cabin this power, and in certain circumstances eliminate the power, at least for now. But and I think the debate has to be, what is the right sort of regulation of this power, and should it be solely within the executive branch, or should the Article 3, the judiciary also be involved in essentially some sort of oversight over domains that historically have not been, have been within the purview of the executive. And the question is whether, with the pace of technology and sort of the pace of surveillance technology, whether it warrants going beyond that.
Thank you.
So I'll just pick up on the last thing that Seth talked about, namely this distinction between metadata and content, because it is something that the government always responds with. Well, we're not reading your texts, we're not listening to your phone calls, we're just keeping a record of who you called, who texted, when they texted, how long you spoke. And I think that's a misleading response for a number of reasons. One is that those connections can tell an awful lot about your activity. So if they show, for example, that somebody called their boyfriend, then within a short time thereafter, they went to the pharmacy and purchased a pregnancy testing kit, and then a short time later, they made a call to an abortion provider. That tells you a fair amount without having to look at content at all. And in fact, Stuart Baker, who was the general counsel of the NSA, once said that, if we have enough metadata about people, we don't need content. Metadata tells us so much. And in fact, metadata is in some ways more valuable to the government because they can use data mining with respect to metadata. It's much harder with respect to content. You don't have to listen to the conversations. You just, which computers can do, but with much greater difficulty, you just look at the metadata. When I quoted Stuart Baker to Mike Hayden, who was the former head of the NSA, in a debate that I did with him at Johns Hopkins a couple years ago, he said, "That's absolutely right. We kill people based on metadata." And then he, assured the audience that we don't kill you based on metadata. But what he meant to say was metadata is so good that we use metadata to make assessments about who we execute using drones around the world. So don't be fooled by the notion, metadata isn't actually telling the government all that much. If it tells them enough information that they can kill somebody, then I think we ought to be concerned about that information. That's number one. Number two is that the government does not, this Fourth Amendment doctrine is not limited to metadata, and the government's arguments with respect to the Fourth Amendment doctrine is not limited to metadata. The government, part of what Edward Snowden showed us is that under a program called the Upstream program, the government is collecting the contents, not the metadata, but the contents of millions and millions and millions of international communications every day and searching through them, even where they involve communications between Americans here and people abroad. And increasingly, we are communicating with people abroad because the digital age allows us to do that. So when you read The Guardian online or you look at BBC online, that's an international electronic communication, and the government on the Upstream program can suck that up and search through to see whatever it wants to see without, under its view, without any constitutional constraints. That's part of the program that still exists. It's coming up for reauthorization at the end of this year or next year. I can't remember now whether it's 2016 or 2017. But so one, metadata tells the government a lot. And we ought to be concerned when the government can get that kind of detailed information about us without individualized justification. And two, this notion that when you share something with a third party, you've given up your expectation of privacy vis-a-vis it. It's not limited to metadata. It applies to content as well. And so unless we revise that doctrine, unless we say, no, just because you sent an email over the internet, and therefore it went through an internet service provider, and therefore you shared it with the internet service provider, that doesn't mean the government ought to be able to get it without making any showing of probable cause and a warrant.
Okay, so I'm going to ask you all to join me in thanking our presenters, but don't sit down if you have questions. But for those who have to leave, I want everybody to have an opportunity to thank our presenters for a great afternoon.